Good morning, everybody. Thank you so much for giving me this opportunity today to swap less than an hour with all of your teachers, swap places with all of you. So just yesterday when I was just speaking about this webinar to my mother, she told me in Malayalam, നാട്ടിലത്തെ teachers ആ ചോദിച്ച ചോദ്യത്തിന് ഉത്തരം കൊടുത്തില്ലെങ്കിൽ chalk എടുത്തെറിയുമെന്ന്. So I hope I don't get the chalks from all of you. But yes, just diving right in, let me just share the presentation with you. When we are speaking of intellectual property rights, one of the questions that you probably have in your mind is, what does intellectual property have to do with me? That must be something that has crossed your mind. Now let's look at it. It can be the pizza you ordered last. It can be the phone that you used to make a call to your loved ones. So yes, like I said, the question that most of you would have is, what does intellectual property have to do with me? So again, like I said, it can be the pizza you last ordered. It can be the phone that you used to speak to someone last. It can be the book that you sat reading, sipping a hot cup of coffee. It could be the university you're teaching at, the laptops you use to do your work, the music you listen to, or the movies that you watch. There's intellectual property, right? There's intellectual property all around us. And as humans, we all create different things. We all create various things. It can be a song, a food product, a story, a new plant variety, a software that you find, a product or an invention that you make. All of these creations are a result of human genius. And such creativity should be encouraged. Such innovation will have to be encouraged and protected. That's the only way innovation will be encouraged in all walks of our lives. What's the point in having a good idea if someone else just takes it away from you and uses it or monetizes it without giving you any onus or ownership right over it, right? So also to explain how important this is and what is the value that this can add, just to give you an idea, Apple, the brand Apple, is valued at $241.2 billion. The brand Toyota is valued at $41.5 billion. Google is $207 billion. HDFC Bank is 22.7, Coca-Cola is $84 billion. So this is the kind of numbers that a brand by itself can bring to you. This is the kind of value that a brand itself can bring to you. But IP is not just about big businesses, right? It affects you and me also, because we all should know about it, because if you have an idea and you make a creation out of it, you should probably want to protect it and want to reserve your right to monetize it as well. And that's how IP rights come into picture. That's why rights over IP, right over an intellectual property, becomes important. And when we think of property, we think of land, we think of, it can be land, it can be building, it can be car, it can be an equipment that you have, a machine, a big machine that you have, any of this. You tend to add value to it, right? You can associate some kind of a number, some kind of a value with it. And these are tangible properties. When we are speaking of intellectual property, it is an intangible asset. It is an intangible property that we are talking about. So therefore, IP protection becomes important, and it comes in different types. It can be trademarks, copyrights, patents, trade secrets. It can be a geographical indication. It can be plant varieties, design rights, any of this. It can fall under any of the buckets. These rights are essentially to protect your, say, artistic work, your story that you wrote, your poem that you wrote, or a thesis that you wrote, your literary work that you, any other literary work that you have, a painting that you made, a software that you programmed, your domain names, your films, sound recordings, everything, all of these things. It can be the any invention that you've made as well. So these are the different rights that will have to be, these are the different areas which will have to be protected by intellectual property rights. We can go over each one of them, the main categories. We can start with trademarks. Now, all of you see the picture in the slide, right? In this picture, there are 22 logos here. And chances are most of you are able to recognize each of the brand or each of the company associated with the logo as well. Now, while I was preparing the slide yesterday, my 6-year-old daughter was reading aloud from behind me, and she was able to identify a lot of these logos by herself. She could identify Google, Facebook, Amazon, McDonald's, Disney, Cadbury's, Twitter, Apple, Amazon, all of this. And I was quite surprised because I didn't know she could name so many. But that's the success of all these brands. The capability of being recognized, the capability of recognizing their goods, their products. That is what a trademark is. Trademarks are basically graphic representation of your business name or your mark. And why is this important? Because this helps you in distinguishing one company's product from another, or one company's service from another company's service. So again, what can you trademark? You can trademark names, you can trademark logos, words, shapes, or any combination of the same. Even celebrity names can be trademarked. For example, David Beckham, Michael Jordan, Beyonce, Donald Trump, SRK. These are all the famous celebrity names that have been trademarked. How is trademark registration possible? Trademark registration, you can make an application to the trademark authorities, and the duration for which you will be receiving the registration for is 10 years. And this is you can renew it post 10 years as well. The timeline from which you make the application till the time you get the registration would be around 6 to 8 months. It would take 6 to 8 months for you to receive the trademark registration after all of the formalities. But why does it become important? It becomes important because it helps you in preserving the quality of your product. It helps you in preserving the in restricting anybody else from producing counterfeit products or producing any other spurious products, and diluting the value of your product or your brand as well. So that's why trademarks become important. Now, the next thing we can look at, the next bucket that we'll be looking at is copyright. Copyright is basically an automatic right that you get when you create the work. Upon creation itself, this right comes to you. So there need not be, it is not mandatory for you to register or get registration for your work. The minute you prepare, you create the work, this right comes to you. You become the automatic owner of the product, your work product. What are the different examples that we can look at? We can, it can be books. It can be books you write. It can be a photo that you took. It can be movies you make, music you make. It can be softwares, computer programs. It can also be your thesis. So when we are actually looking at plagiarism, for example, of a thesis, in a thesis, it's not just cheating. Plagiarism is not just cheating. It is also infringement of somebody else's copyright. And these are the examples of different copyrights. Now, copyright is given not for an idea. It is for how you express the idea, in what material form you express the idea. So when we say someone has copyrights, we are talking about a bundle of rights. And what is the bundle that we're looking at? Two broad divisions. The bundle that we're looking at, the different rights that a copyright holder will have, is economic right and moral right. When we are speaking of economic rights, it can be the right of distribution. That's the right to sell your work, the right of reproduction, the right to communicate to the public, the right to translate or adapt, the right to make a movie of it or make a sound recording of it, or any rental or resale rights as well. And when we are speaking of moral rights, these are rights of authorship, that is the paternity right, right to be called the author of a particular work, and right of integrity. Right of integrity is basically the right to not distort the work, not let anybody distort or mutilate your work. Those are the two major rights, economic and moral rights, that you will have as a copyright holder. Now, registration of copyright, like I told you, is not compulsory. It is automatic. It comes to you as immediately upon creation of your work. But registration of your copyrighted work, your work is possible. Registration of your work is possible. you can apply to the copyright authorities. And what will be the advantage of getting the registration? It becomes easier when you, if at all there's a dispute, when you go to a court of law, it becomes easier for you to establish your copyright in the court of law. And when we are looking at copyright registration, it is usually for in case of literary, dramatic, musical, and artistic work. It is usually the duration of registration given as lifetime of the author plus 60 years. And for all other works, it is 60 years from the date of publication. There can also be a scenario where you are jointly authoring a paper or a book with somebody else. So joint authorship is also possible, where both the authors will be the joint authors of a particular work. And the duration for copyright then will be the lifetime of the authors. So in case one person passes away, the lifetime of the living author plus 60 years is what we are looking at as registration duration or copyright protection duration. The interesting point here is who will be the first owner of copyright. Now, logically, you and I would say that the first owner will definitely be the person who writes a particular work or the person who's the author of a particular work. That's logic, and that's absolutely right. But there are some exceptions to this rule. The exceptions are, in case of literary, dramatic, artistic work, when this is being done in the course of one's employment, it becomes the author, the first owner of the copyright becomes the employer here. That is, when you are creating your literary, dramatic, or artistic work during the course of your employment, then your employer will be the copyright owner, the first owner of copyright. The next exception is in case of a photograph or a video or a portrait, which is commissioned work. So somebody pays for it and asks you to make it. Then they become, the person who commissioned you to do it, become the first owner of copyright. In case of a speech that you delivered in public, then the person speaking becomes the first owner of copyright. In case of any government work, the government becomes the copyright. These are the various exceptions given under the Copyright Act. There is also an interesting case on this matter, which most of you may be aware of. This is the case of V.T. Thomas versus Malayalam Manorama. Where Mr. Thomas, who used to be a cartoonist for the famous cartoon Boban and Molly, was working with Malayalam Manorama. And what happened in this particular case was, while he was working with Malayalam Manorama, this cartoon became very famous during that time. And for some reason, his employment was terminated. And then he started working for another magazine, Kerala Kaumudi, where he started drawing the same Boban and Molly cartoons as well. Malayalam Manorama filed a case against Toms, famously called Toms, against him. And the High Court of Kerala here held that all the work that Mr. Thomas had done during the course of his employment with Malayalam Manorama becomes theirs. They are the first owner of copyright there. But when we are speaking about the character, Boban and Molly, apparently he had started making the characters or doing this cartoon even before he even joined Malayalam Manorama. And therefore, interesting part here is the court held a distinction, made a distinction between the two: the ownership of the work done during your employment and the ownership of your cartoon character that you came up with. So here the High Court of Kerala said Mr. Thomas has the right to continue using the characters as such, and he can continue to make cartoons for any other publication as well. This was a very interesting case and quite a landmark case in the copyright regime. So one thing that we will also have to remember is when we use a material from another author in our work, it is important to ensure that the actual author is provided credits to. So we should be providing credits for to the actual author. So this is largely what copyright is and the boundaries of it. The next bucket we'll be looking at is patent. When we are speaking of patent, patent basically protects any invention. Any invention. It can be a product or a process. The requirements, the conditions that it will have to satisfy is that it will have to be new, it will have to be inventive, and it should have an industrial application. Then it is eligible for getting the patent, the right of patent. Now, this is a valuable right provided to inventors. And why is it a valuable right? Because here what happens is the state is giving you a monopoly right over a particular product or a process for a specified duration. And the duration that you're looking at, the registration is given for 20 years. So for 20 years, you will have monopoly over the product and the process, whatever it is. You can restrict anybody else from manufacturing the said product or manufacturing using the said process. That's very important for, especially for companies like pharma companies, where they spend, this is just because of the patent protection, this is the main reason, the patent protection granted is the main reason why all of these companies invest millions into innovation and R&D. So this is mainly done because the protection is given, there is a monopoly right, and this will encourage more innovation in the various fields. So patent, when you look at it, apart from the rights of distribution and sale, you can also license, you have the option to license your patent to somebody else, or you have the option to assign or sell your right to anybody else. But these are rights that you will have for any different bucket of IP that you're looking at, intellectual property that you will be looking at. The next bucket that we're looking at is geographical indication. I'm sure all of you have heard of Aramula Kannadi. That is an example of GI. Darjeeling tea, Kanchipuram silk, Basmati rice, Kolhapuri chappal, Scotch whiskey, Swiss watches. These are examples of geographical indications or GIs. These are GIs. Now, what are GIs? GIs are signs that you use on goods that have specific geographic origin and possess certain qualities or reputation due to its place of origin. That's what GI is. Now, why would GI be important? If you look at it, now, for example, Aramula Kannadi itself, it helps preserve the traditional knowledge of a particular place, and it helps the traditional cultural expression as well. It can be any product, any GI product that you're looking at. And it also helps the producers belonging to the said place. Now, certain products have certain qualities or characteristics especially because they are from a specific place. Often consumers are prepared to pay more for such products because of the value, because of this value that it has. And this helps development of specific markets of products with certain characteristics. So for example, champagne is a good example, or say Swiss watch is a good example. So these are good examples of GI, and why you would have to protect it is because of giving that edge to that specific market, of helping preserve traditional knowledge of a particular place, or helping retain or preserve the quality or characteristic that you have in a product when it is made from a particular place, say a Darjeeling tea. Now, tea grown in any other place may not have the same characteristic that the tea from Darjeeling has. And it is only for the reason that the tea from Darjeeling has certain characteristics that me as a consumer will be ready to pay a little extra as well. That's why geographical indications also become important. Now, when you're looking at geographical indication, who can apply, who can make a registration is anybody who is representing an association of persons. It could be an association of persons, it could be an organization, an authority representing interests of producers. Any of them can apply for registration. And this is also a deterrent for avoiding free riding on reputation built by a certain group of people or people belonging to a certain place. This is also important so as to not dilute the quality of the product as well. And when you apply for registration, the registration is given for 10 years, and renewal is also possible. You can renew it from time to time. Once your period is almost getting over, you can also apply for renewal. The next broad category that we are looking at is plant variety. Now, plant variety is basically this part of IP gives legal protection to the farmers and breeders who discover new plant varieties. So the right as such is called plant breeder's right. Now, there has to be some conditions which will have to be satisfied for you to get this kind of protection. One is that there will have to be novelty. There should be something new, something which has not been previously commercially been exploited. And there should be distinct, it should be a distinct, plant variety. And the third thing is that there should be stability. That means this variety can be reproduced or multiplied without losing its inherent characteristic again by somebody else. So the variety can be reproduced again or can be multiplied again by somebody else. That is also another condition that will have to be satisfied if you want to get the registration as a plant variety as well. Again, who can register? Whoever is a person who has come up with or developed this new or propagated this new plant variety can apply for registration. And by registering, you will have the exclusive right to produce for sale and to sell the material. You will also have the exclusive right to sell your plant variety. This will also help you from preventing others from using your plant variety without your permission. There's an interesting point here. You cannot, also another condition when the registration or the protection will be granted to you is that you cannot sell branded seed of a variety. Branding is basically not permitted. And second thing is that researchers are allowed to research or study your plant variety. They can be, they can be given access. They will have the right to study and research on your plant variety that you have developed or propagated without commercially, of course, exploiting it. So these are the different buckets of IP broadly when we are looking at, And when you're looking at the registration duration, again, like it's mentioned, for trees and vines, 8 years from the date of registration, and for extant varieties, it is 15 years from the date of notification of that variety by the central government. And in any other case, it is 15 years from the date of registration. These are the broad categories of IP that we come across in our daily life and which we may not know is actually an IP. When we use the terminologies in IP, we tend to largely loosely use the words, say trademark, patent. So now you definitely can understand when you can use the different kinds of categories of IP. And how do you exploit your IP? Of course, you can sell your own product in the name that you coined, or you can sell your own product with your IP, or you can also have a licensing arrangement with somebody where you are actually giving them a license, which means you are giving somebody else a permission to use your product. Say, for example, I have a product that I've come up with, and I'd like to give somebody a permission to sell the product in a specified territory or for a particular number of years. I can do it. And this is called licensing, where you allow somebody else, you give permission to somebody else to you sell, commercially exploit the product with the commercials that you agree with the other person. And the other way of exploiting your work commercially is by assignment or by selling all your rights to somebody else, assigning your rights to somebody else. Even here, it can be perpetual or it can be for a specified term. The assignment can be territory specific, or the assignment can be worldwide, anything, depending on what your commercials are with the other person. It is for you to contractually agree upon how you want to commercially exploit a particular intellectual property that you have come up with. And finally, what we will be looking at the last slide is the legal remedies. So what happens if you infringe on somebody else's or violate somebody else's copyright? What are the remedies that they will have against you? Or in case it is your copyright, that's your intellectual property that somebody else is violating, what are the remedies that you will have under law? Broadly classifying it, you have civil remedies and criminal remedies as well. Criminal remedies, of course, criminal prosecution per the legislation that you're looking at. And civil remedies, you can go in for injunction, where the authorities will basically order a party from desisting, order a party to desist from an infringement. And you can also claim damages. Damages meaning you can claim compensation for the injury that is suffered to you, that you have suffered. And you can also ask them to indemnify you, compensate you for all your losses, that is as per your contractual agreement with such person. And you can there is also a right that you have to request the court to ask for seizures or raids. Basically, whatever products that have been manufactured with using your IP can be seized through court means. So these are the legal remedies that are largely available under Indian law. And this is pretty much similar worldwide as well. So yes, those are the main, what can I say, that is how I can summarize and keep it, I wanted to just summarize this whole thing and keep it very simple for you to understand. And if you have any questions, you can definitely ask me. I hope I have clarified your doubts and helped you understand the concept of IP here.